and we're live on LinkedIn, YouTube, and Twitter. So it usually just takes a second or so, and I start to see people file in. Well, I sent out an email a couple days ago, another one this morning, reminding people that you were coming to join us here today. And so I can see that people are starting to appear.
Great.
Where are you today?
Where am I? I'm in my home office in Virginia Beach, Virginia.
Oh, okay. I was in Virginia a couple weeks ago to catch the auto train down to Florida. Took my kids down.
Oh, cool. Yeah, Lorton, Virginia, I think is where it originates from.
Yes.
So,
All right. We got people coming in, so I'm going to get things rolling here, and we'll be right back.
I'm David C. Barnett, and you're tuned in to Small Business and Deal Making, the podcast, YouTube channel, and blog where I talk about buying, selling, financing, and managing small and medium-sized businesses while controlling risk. So if you're looking to take control of your future through buying a business one day, or if you already own a business and you're looking to grow or exit, you've come to the right place. I talk about interesting things, I talk to interesting people, and I answer your questions every week right here. So be sure to hit like and be sure to hit subscribe, and let's get to it.
All right. Welcome, everyone. Thanks for taking some time out today and joining us. I am joined today with my guest, Joel Ankney, who was a guest speaker in the Business Buyer Adventure Group coaching program a couple of months ago. And I wanted to have him come back to the main YouTube channel so we could have a chance to ask him some more questions that everyone will be able to learn from, but also that people in the general audience will be able to ask questions of Joel as we get rolling here today. I think I'd like to begin, though, Joel. Maybe if you can give an introduction, tell us a little bit about your background, how you got into practicing law, and the type of work that you're doing most often.
yeah, that'd be great. That's kind of a loaded question, how I got into practicing law, but we won't go too far into that. But I just needed a job, so law school looked interesting, and that's where I went. I always wanted to do transactional work, and I went to law school with that intention. And after I graduated from law school, I practiced at some large law firms in Virginia for about 12 years, doing transactional work, doing a lot of small to medium-sized business transactional work. 20 years ago, I left. I started my own solo practice. 6 years ago, I published a book. I know we're going to mention that a little bit, but my primary focus is on small and medium-sized business merger and acquisition work. And that's what I spend. I'm not a trial attorney. I spend almost all my time just doing these SMB deals.
Yeah, and this is how I came to know you, because I heard you interviewed on someone else's show, and you mentioned your book. Here's the deal. I put the picture up there on the screen,
Yeah.
and I bought the book, and I was really impressed with it, because so often when we find books that talk about small business, what they're really talking about is what I categorize as mid-market, where they're talking about businesses with several million in revenue. And when I use the term small business, I often mean main street businesses. So like the types of businesses that people most often interact with, that you can imagine have, maybe they have some employees, maybe they have a dozen employees, but they certainly aren't doing millions and millions of dollars in revenue. And so when I read your book, it really resonated with me, because you were talking about working on deals that were sort of in that same magnitude, that same size.
Yes, I mean, and the book, one of the main purposes for the book was to provide a resource to those types of businesses, those types of business people either selling their main street businesses or people who are looking to buy those businesses. Last year, for example, I closed 22 transactions. The range of purchase price went from $65,000 for a small martial arts studio to $55 million for a multi-location storage facility business. But most of my transactions are in the purchase price of about $1 million to $5 million. So that's really who I'm working with every day. And that's why I wanted to provide them with a resource to help them through those transactions.
And when you're working on these deals, who are you most often representing, buyers or sellers?
I think I want to say it's probably slanted more toward heavily more on the buyer side than the seller side. Of the 22 transactions I did last year, I would say probably 15 of them were buyer side transactions and the other 7 were seller side.
Okay. And you know, is there any particular industry or anything, or does it run the whole gamut of all different kinds of things?
I've sold all kinds of businesses, everything from small family-owned pizza parlors to wellness businesses, e-commerce businesses, financial services businesses, fitness, just construction businesses. The transactions I'm working on right now are, uh, publishing business, event planning business, um, a wellness business. So yeah, I mean, really, the industry itself, I'm not. Um, I usually try if I need to learn about the industry, I can do that as we're working on the transaction. So it's been fun. That's part of what I like doing the transactions is because I get to learn about the business in a way that helps us kind of manage the risk as we're doing the transaction.
So 22 purchase sale transactions over the run of a year, would that be sort of your average workload that you've been doing for a few years then?
Well, I've been doing transactions for 28 years, I guess. When I first started practicing, I did something else, but we were in a recession. So once the recession was over, we got out of that. But yeah, I'd say 22 transactions in a year is pretty typical. The price range that I usually don't do deals as high as 55 million. Most of my deals are 1 to 5 million. That was just a kind of an anomaly last year. So far this year, my biggest transaction is about 16 million. But again,
Okay.
it's an outlier.
Now you're interacting with these deals from the point of view of an attorney, and so you're looking at the legal stuff and the paperwork. But have you noticed any kind of change in what's happening with these deals given the rise in interest rates over the last year or so?
Yeah, that's a great question, and I was thinking about that before we got on. So far, not really. I have not seen at least from my perspective, a slowdown in the number of people doing transactions. One of the things that I have seen over the last 5 or 6 years is the ability to obtain an SBA loan, a Small Business Administration loan, has actually become easier than when I first started doing this, 20 or 30 years ago. So because of that, I am seeing a lot of people who are perhaps, I mean, again, prior to say 2018, I had probably only closed, 5 SBA loans in my career. But since then, I've probably closed, um, I don't know, 20 or 30 SBA loans. And that, so I have seen that difference as far as the ability to obtain financing seems to be a bit easier on the SBA side, at least. But I'm
Yeah.
waiting for
And
that correction, right? Like you're waiting for that. Since interest rates are going up, I'm waiting to see how that's going to impact everybody.
Well, I know that since I got into business brokerage, the very first time I was in the States doing training, when I was earning my certification and whatnot, that was the moment when I ran into more people on the American side who were doing deals. And I can tell you that at that time, I don't know how difficult it was to get an SBA loan, but they certainly weren't financing up to 90% of transactions at that time.
Right.
So a
Right.
lot of different things have changed with them over the course of time, not just maybe how easy it is to get, but the degree to which they're willing to offer leverage.
Yeah, I think so. And I think one of the things I mean, I don't have any like evidence to support this, but my observation is that certain banks have gotten very good at creating a process to make the SBA lending process a lot faster, easier on the borrower, and because of that, they're able to do a larger volume of those loans.
Um, you know, what you mentioned, closing an SBA loan. I just like to get some insight into how it's different for you from a contract and legal perspective to do an SBA loan versus any other kind of normal loan from a bank.
The main difference is that the SBA loan is just going to require more documentation. And also the SBA loan, the lending requirements are going to perhaps impact the way that we structure the asset purchase. So, for example, in my book, I talk a little bit about earnouts and earnout agreements for post-closing, a way to kind of shift part of the purchase price to post-closing performance of the business.
Yeah.
In an SBA loan, the SBA won't allow an earnout agreement. So as a result, we have to structure, if we want to have more of a performance-based compensation after closing, we have to structure the transaction a little differently. And the way we typically do that is with a seller financing promissory note that has a forgiveness, some forgiveness terms and conditions in it if the business doesn't hit certain thresholds of revenue and things like that. But that's mainly from my perspective. I have to make sure that because really what we're doing is we're closing two deals. We're closing a loan deal and we're closing at the same time a purchase. And I just have to make sure that the two dovetail together. And the SBA has more requirements than a commercial lender does.
Okay. We've got people piling in. We've got Kevin here, who's in Lakeland, Florida, says good afternoon. Hey, Kevin, thanks
Great.
for joining us here today. Another question here from Concise Advice is curious, how many of those deals that you did were involving a business broker?
Almost all of them. But almost, I think in every instance, the seller also had their own attorney.
Okay.
So I saw that in
And-
her question.
Well, would that, I mean, as far as I'm concerned, both parties in the deal should obviously have their own attorneys. Do you
Yeah.
meet a lot of people who want to do the deal with only using one?
I don't meet a lot of people, but I do meet some people. And I had an experience even just last week where I was representing a potential buyer in a transaction, and the broker didn't want really to have the lawyers involved. They wanted, it was a weird thing, and it was something that I never had really encountered. But the broker had a fill in the blank asset purchase agreement for a deal of approximately $2 million. And they simply wanted the buyer to fill in a couple of blanks and send them the asset purchase agreement. This was, and what they were, I think part of what they were doing was they were trying to have a bidding war with buyers. And so, they kept pressing my client to do this, even though we actually had a letter of intent that had an exclusivity period in it. And they basically just said, well, we're not going to honor that. You need to, and it has to happen this afternoon. All those are red flags to me, right? Those are, and that's what I told my client. I said, I would advise you, if you can't trust the broker to honor the letter of intent and the buyer, or I'm sorry, and the seller, then, this is it's just a red flag of potentially what's going to happen down the line here.
So you've worked on a lot of deals. You talk about things like ignoring a condition in the LOI as being a red flag. I think that makes pretty clear sense. What are some of the other common red flags that appear from time to time for you that give you concern?
I think that one that you've already mentioned is the idea of if a broker is involved. And again, I'd say 90% of my transactions have a broker involved. And the broker doesn't want the attorneys to be involved for one reason. They might say, well, the attorneys are going to muck everything up or slow everything down. And that is kind of a red flag. Usually we push through that one. That one wouldn't cause me to tell my client, hey, don't do this deal. But other red flags might just be, a lot of these red flags don't show up until we get into due diligence, right? I mean, when we get into due diligence, then we start to see, if we see odd things. I remember working on one purchase where there was a line item on the financials for miscellaneous, and it was like $2.3 million for 1 year, an expense of, and what ended up happening is they discovered that the bookkeeper inside the company had been embezzling. That was her line item for money that she was embezzling. And
Wow.
so, we actually did the transaction, but it ended up discounting the purchase price quite a bit. So,
Wow. Well, I mean, if you got rid of the embezzler, the cash flow would improve immediately, wouldn't it?
right, exactly.
I actually had a similar thing happen where I helped someone buy a bar, and shortly after the purchase, the new owner, who was much more of a systems kind of person, implemented a better inventory control system and quite quickly found someone who was involved in pocketing some cash.
Wow.
And it turned out the business was much better than they had initially thought when they made the deal. So, these kinds of things can happen. And sometimes things you don't discover in due diligence can actually be a benefit to the buyer, I guess, in that kind of scenario.
Mhm.
What are some of the common problems that come up with deal closings?
Well, I think that I don't know if the challenges with closing a deal involve the time that's necessary to work through a lot of issues. And when I think of closings, things that slow closings down are lenders and landlords typically. So I'm closing a transaction later this week where we have 4 landlords involved who have either had to give my client, the buyer, a new lease or consent to the assignment of the existing lease to my buyer. And for the most part, the landlords, it's not one of the things that they put at the top of their list, their to-do lists. Um, and they have to do their own, they have to vet the buyer as well, and those things just take time. I think that people would be surprised to see one of my closing checklists, because there could be anywhere from 50 to 70 items that I'm working on and sometimes I'm relying on third parties to get things done, but there are a lot of moving parts. And I think that it's when we're dealing with third parties that we run into some issues typically that we have to resolve.
Yeah. You've already mentioned, loans and loan agreements and the documentation they require. And now you're talking about landlords and things.
Mhm.
And of course, then there's the purchase and sale agreement. When we talk about closing and sort of the legal work that goes into closing, you just mentioned 50 to 70 things. And on your previous visit with the adventure group, you talked about how you use a checklist. I've back in my broker days, I know I went to several closings with clients where sometimes there would be, a few contracts for people to sign, and other times there would be a literal mountain of things that would have to be signed and sometimes spread all the way down a boardroom table.
Right.
Can you talk about some of the other things that can sometimes happen and just why it can create so much work for the attorney, and maybe to show people why this isn't, a 1 week kind of job oftentimes for most of these deals?
Yeah, this is one of my favorite topics, frankly. The timeline necessary to go through the process is typically longer than most people anticipate. I find it interesting that the the business people spend a tremendous amount of time and effort on finding a target, a buyer finding a target, and then kind of analyzing different targets that they have, and then deciding on the one that they want to pursue. And many times what I find is that once they sign the letter of intent, everybody kind of sits back and says, okay, the deal is done. And from my perspective, that's when the deal just gets started. Most of my clients hire me either right before they sign the letter of intent or right after they sign the letter of intent. Um, then, once they sign the letter of intent, of course, we're into the due diligence period, and that might be anywhere from 30 to 90 days. My involvement in the due diligence period is typically pretty limited. And we can, talk about that. But then once we get through the due diligence period, we're going to draft an asset purchase agreement, and that's going to take some time too, because there's going to be a lot of back and forth.
And this is when the buyer has said, yeah, everything looks good, I want to proceed. Then they're going
Right.
to get you to actually do the work to make the deal happen.
Exactly. And there's going to be a lot of back and forth on that. And because there are important aspects of an asset purchase agreement that are in there to control risk, and especially from the buyer's perspective, we want to make sure that when we're doing an asset purchase agreement, that we're leaving all the liabilities with the seller, and that we have a mechanism in there for us to pursue the seller if there are problems after closing. But once that's done and we're talking about closing, we have a number of other legal documents that have to be created and then signed. And some of them are just related to a legal document that actually transfers title to certain types of assets over to the buyer. So, for example, a bill of sale is used as a title document, a title transfer document, to transfer title to the tangible assets over to the buyer. So if we had a vehicle, we have a title document, right? But if we have computer equipment and inventory and things like that, we don't have a title document. So we use a bill of sale to transfer that title. So a bill of sale is something, if there's a seller financed promissory note, we've got to have that promissory note. That promissory note typically is also tied to a personal guarantee. So that's another separate document. And if there's a pledge or a lien that's given on the assets as collateral for the promissory note, that's another document, a security agreement. Contracts are assigned using a separate assignment of contracts agreement. Leases are assigned using a separate lease assignment agreement. If a landlord needs to consent, there's a legal document for that. If there's a non-competition and non-solicitation provision, most times we have a separate agreement for that post-closing, and there's a reason why we have a separate agreement. If there's a consulting agreement for post-closing seller services, that's another agreement. If there's a escrow of some of the purchase price, for example, to handle post-closing indemnification claims, there's a separate escrow agreement. There are corporate resolutions and certificates that have to be provided. And then we haven't even talked about all of the financing documents. There's going to be a whole separate package and I don't draft those. The lender will draft those, but there will be a whole separate packet. And frankly, the financing documents can be a lot more. There are going to be a lot more documents. That's going to be the thickest stack of documents typically.
And I would imagine sometimes too, in some of these deals, you may also be creating some new entities too, and all of the paperwork associated with doing that at the same time.
Yeah, exactly. And that's a really good point. I mean, we're typically always creating a new entity. It may be one entity. In some instances, I'm working on a transaction right now. We're going to create two new entities one entity to take a certain type of assets and another entity to take another type of assets. And there's a tax purpose for that. So that I'm not an expert on.
I would imagine an asset protection strategy involved in that too, perhaps, maybe.
I think there could be, but this one is primarily driven by the tax planning that's taking place.
Okay. You mentioned, for example, in the asset purchase agreement that you want certain clauses and certain protections.
Mm-hmm.
Are there any sort of deal breaker things from your point of view where if they're not in that deal that you will tell your client, like, I would seriously worry about doing this deal because you're missing this really important thing?
Yeah, I mean, I think that when we're talking about important things from a buyer's perspective in an asset purchase agreement, we're focused heavily on making sure that my buyer is getting what they think they're getting. So we want to make sure the list of assets is comprehensive and detailed. If a seller is unwilling to provide a list of assets, that's a yellow flag, I think. When we talked before, we talked about an experience I had where a seller would not provide a list of inventory, even though they claimed that inventory was worth, I can't even remember, but it was like somewhere between $5 and $8 million on the balance sheet as the value for inventory, but they couldn't produce a list of inventory. And that was a yellow flag that became a red flag when we did a little bit more digging. And again, they were just unwilling to provide any sort of assurance that we were actually getting, $8 million worth of inventory. And my client walked away at the closing table. I mean, he literally just said, if you can't provide this, we're done. So,
Yeah.
yeah.
Now, if I recall, when you told me that story last time we spoke, you then went on to say something and tell an interesting story about something you discovered about the seller.
Yes. I mean, because we had pressed for the inventory list for many weeks prior to closing, and we basically got stonewalled on that. And so that, I'm not sure exactly what triggered my thought to try and do a little bit more research and diligence on the individual sellers, the people who own the company that was selling the business. But as we just did some quick Google searches on these individuals, and we found out that they had several years, maybe I can't even remember, 5 or 7 years prior to this transaction, they had settled, they had pled out basically on some criminal fraud charges related to another business that they had had in the past. So when they wouldn't provide the information that is really, I mean, an inventory list is customary, it's reasonable to ask for. And when they wouldn't provide that, and then coupled with the their history, kind of their colored history, that's when my client decided he didn't really want to take the risk.
Well, when you talk about the legal work to close a deal, there's also the legal due diligence. So what would you so let's say we've completed the due diligence phase as far as numbers and everything that I'm looking at now. I say to you, yes, let's move forward. You're going to do some pretty basic checks on the company or the business and its status, and if there's different things outstanding. Can you describe what that legal due diligence often looks like?
Sure. I mean, we're going to look at, yes, I'm going to go to the state. The Secretary of State is going to have a website where I can search the business and I can see if they're in good standing, see who the officers and directors of the business are. And I typically take a very quick look at the history. There's not a lot of information available in the Secretary of State's records, but what's public might clue me into search a little further. If I see some merger documents from a year ahead, prior or something like that. A lot of times what that does is gives me information that allows me to create questions to ask the seller. Tell us more about this. Tell us more about, we saw this, but there's not enough information there for us to understand it. Tell us a little bit more about that. I'm also typically going to do if I can, in the public records, a UCC search. So I'm going to look at whether there are any liens filed against the assets, because again, I want to know who's out there so that we know who needs to be paid off at the closing. Frankly, every once in a while, I'll run across a seller who won't want to tell us about something, a liability that they have that needs to be paid off at closing. Otherwise, that liability is going to essentially transfer with the assets themselves. Other things that I'll look at are key contracts and leases to determine whether they can be, for example, if they require the consent of the landlord or the other party before they can be transferred. In some instances, for example, I'm dealing with a transaction right now where the contracts don't indicate that they require consent to be transferred, but they give the other party the right to cancel the contract at any time. And so I warned my client that, hey, just so you know, if they don't like you after you buy the business, they can just terminate these contracts. They could all go away. So those are the types of things I'm looking for.
And so doing due diligence on a business, of course, is different than doing due diligence on a person. Like you mentioned before, doing
Right.
some Google searches on that seller. You know, I actually had a client a couple of years ago that was looking at doing a business deal, and one of the things that came up was that this person didn't have a LinkedIn profile. They couldn't find them on Facebook, all these kinds of things, and it was a new person to the area. And I thought, it might make sense to have this person checked out, and they didn't. And then it turned out that this person was, deceptive, and it cost them money. And they really should have spent more time investigating the individual. You've got a similar story that you can share about, nefarious characters in this world of buying and selling businesses.
Yes, yes. I mean, I do. I mean, I mine's a little different because the transaction had already been closed for about a year, and the buyer came to me and asked me if I would help him enforce some contracts against the seller because the seller was had become very upset about certain things after closing. And as I look through the documents, and I mean, this all happened for me in the course of one afternoon. I looked through documents that were delivered to me that afternoon, and then I called the buyer and asked some specific questions. The answers weren't satisfactory to me, so I actually declined to represent the buyer. I just, and that for 6 months, I didn't hear another thing about it, and then actually was mowing my grass when the FBI called me and wanted to know if I represented this individual and what my experience had been with them. I told them my story and I asked them why, and they said, "Well, we've got him in jail right now because he has a pattern of purchasing businesses, financing almost entirely with seller financing, stripping all the assets out and selling the assets, collecting all the accounts receivables and pocketing all the money, and then walking away and to leave the seller to foreclose on a business that has no assets and no, I mean, it's been decimated essentially."
Yeah.
Um,
Yeah. And so the first time I heard that story was around 2008 or 2009. I was
mhm.
in a training session in Ottawa, and the trainer told us this story about the two members of a family that had done this many times before getting caught. And I've made a lot of videos over the years about buying a business with no money, and one of the things that I often point out is that if a seller would let you buy their business 100% seller finance, this is the risk they expose themselves to, that you could simply collect the receivables, sell the inventory, sell off the other assets, and then run away, right, with the money.
Right.
And people will often accuse me of creating this extreme example, but it's not. I mean, this is something that has happened to people before. And it's why it, as a seller, if you're going to do some seller financing, you have to have your banker cap on when you analyze that buyer to look at them and say, is this person really going to be a capable operator, and are they credit worthy, and do they have the right experience, et cetera, for me to want to basically invest part of my money in helping them to acquire this business.
I think that's a great point, and to take it one step further, I tell my sellers who are offering, seller financing, that you need to act just like a bank, which means all those things that you just said, and in addition, you need to ask for the same things a commercial lender would ask for, like a first
Yeah.
position lien on the assets. A lot of times, if there's a commercial lender, you're going to get a second position lien, but you need a personal guarantee. You need a lien on the assets. You need, the same types of things that any other commercial lender would take. And if a buyer is unwilling to give you those things, that's a red flag.
Well, and don't forget reporting. And this is something I've pointed out to many clients as well, is if you're going to hold a substantial seller note, don't you want to see monthly, maybe quarterly P&Ls and balance sheets so you can keep an eye on the business?
Yeah,
Because,
that's yeah.
quite frankly, the seller is often much more expert at how the business operates than the buyer is. And I've actually had cases before in deals that I've brokered where the seller will start to receive reports from the buyer along with their payments every month. And the seller's the one that notices the problem before the buyer is ever aware
Hmm.
and picks up the phone and says, "Hey, I've noticed this is happening. It probably indicates this is going on in the business." And it can actually be very helpful for these buyers because it lets that seller kind of look over their shoulder and they're the ones that have all the experience in the business.
Yeah, that's a really good point. I love that. Yeah.
So we talked about deal breaker conditions. We talked about legal due diligence on counterparties. Just looking down my list of questions here. Um, Let me ask you this, Joel. Have you ever worked on a deal for a buyer on a contingency basis, meaning that if they didn't successfully buy the business, they wouldn't have to pay you anything?
No, no,
Okay.
never done that.
Have ever heard of anyone doing that?
I don't know anybody personally who's done that. I think it's out there in the ether a little bit, like theoretical. I
Yeah.
have
Okay.
people ask me that. Frankly, if I were to take a contingency, you wouldn't like it. You wouldn't be happy with that. Like because the risk that I'm taking on would be high enough that that'd have to really be worth my while. And you wouldn't be, why would you do that, right? Why would you agree to give me a contingency that would maybe, put, let's say, $50,000 in my pocket, where if I did it on an hourly basis, my fees would probably not be any more than ten or $15,000, right?
Yeah. Yeah, no, it makes sense to me. The reason why I'm asking is because people in the comments keep putting in there that supposedly there's an army of attorneys out there willing to help people do this stuff on these kinds of basis,
Yeah.
and I don't think there is. To your point, I think it's just a notion that's kind of floating around out there.
I've never run into anybody who does it. It does, from an ethical perspective, I have to structure my engagement a particular way if I'm going to take a contingency. Um, I've only ever taken contingencies in the history of my practice for copyright infringement claims. Believe it or not, I had some clients who were in the fine arts uh, uh, business and also good friends, and we had several kind of high profile copyright infringement claims, and I took those on a contingency. It's the only time I've ever done something like that.
Well, and I've written about this before, and I've said that if you're going to find a lawyer who's going to do this, it's probably one of your cousins, or a good friend, or something like that, right?
Yeah,
And
I mean, I would be. I don't want to like be critical of my colleagues at the bar, but I would be, I would be surprised if somebody offered it. I mean, I get that question. I always answer no. What I have done in the last 5 years is I will defer my fees to the closing.
Mhm.
Um, but if we don't close, you're still going to pay my fees. That's the way we're going to work it.
Well,
Um,
and that's actually pretty common because sometimes a buyer may want you to address your invoice to the company that they're acquiring,
Yes,
right?
or in my experience, more common is they want to use the loan proceeds to pay for my fees.
Right. And so, one area of law that sees a lot of contingency billing would be something like personal injury, right? And
Right,
and those attorneys who are probably going to look at the case and based on their experience, they're going to judge whether or what they think the likelihood of the thing closing in the favor of their client would be.
right.
And so for you to do it on a contingency basis, you'd have to make the same judgment. So let me ask you this, in your experience, how often do the deals not close after you started working on them?
Well, I think that the if you asked me that question and also asked me at what point during the transaction process do they not close, if we're at the letter of intent phase, I've had clients submit 5 or 6 different letters of intent during a 12-month period, where none of them end up, whether it's because they discover things during due diligence or they can't get the financing that they need for the transaction or something like that. So at a letter of intent due diligence phase, I see, I don't know, maybe 20% if I were to guess, based on my experience. If we get all the way through the asset purchase drafting phase and we're coming up on, just a couple of weeks before closing, I've only ever seen, recently, and I've maybe lost 2 deals in the last 10 years at that point. So I think it really depends on where we are in the process. If we're almost to closing, we're going to close typically, unless something crazy happens.
Yeah, and I mean, legal fees are one of the expenses that people are going to have to pay in order to get a deal done. And ideally, I mean, at least the way I coach people about this is you want to try to get over as many hurdles as you can before you start to get deeper and deeper committed into the process by, having your attorney do things for you. So it makes sense what you're saying. The longer you're in this tunnel, the more
Right.
certain the outcome should become, because the easiest things to derail the deal should be maneuvered around earlier in that process.
That's a wonderful way to put it. Yes. Yeah. And,
Yeah.
and kind of you know, what follows on from that, from my perspective, is that if you engage me, for example, to help you draft your letter of intent or review your intent, and then you decide to terminate the deal during the due diligence period, you've only incurred a couple of $100 worth of fees with me at that point. So it's not as painful as if we've gone through the whole drafting all the documents and we're almost ready to close, and then something weird happens. I mean, I had a deal a year or two ago where we got to the day of closing, and my seller, I was representing the seller, and my seller had signed and delivered all the documents, and the buyer got cold feet and just said, "I'm not going to do the deal." And we went round and round with their attorneys. He was represented by a large law firm, and um, he eventually, after about 2 weeks of us pushing on him, he just said, "If you think you have a claim, you need to sue me, because I'm not going to close this deal." And so he got sued. So not by me, but we hired a trial attorney to sue him. I don't know what the outcome was, but it was that's a very odd and a very unique experience.
That's a big cliffhanger. You need to call that other attorney.
Yeah, I do. I think at one point, I think they were going to settle it. So
I imagine it did settle at some point.
yeah.
Yeah. Can you? I mean, you talked about a few times about sellers wanting to use the same lawyer and things like that. Can you talk about some of the common mistakes that you see being made because people are just being cheap and they don't want to invest in proper advice?
Yes. I mean, I think for one, you know, trying to do it yourself, either because you do some Google searches or you find a website online that sells form documents. I mean, there are plenty of those websites, and you think that every one asset, it's kind of a one size fits all. One asset purchase agreement is going to fit every deal. That's always going to create problems trying to do it yourself. The idea of one lawyer is going to do everything and I mean, I'm in a deal like that right now where the broker hired a lawyer not to represent the seller or the buyer, but simply just to draft all the documents. And that's an odd, I mean, that happens more often than not, but the idea that there's just going to be one lawyer to handle everything is, I think, a little bit of a trap, because that lawyer has to represent somebody typically. And if the broker is representing the seller and they're also engaging the lawyer, it's typically going to be that it may not be stated this way, but that lawyer is going to be the seller's interests. I just received a whole slug of documents today where my client said, the broker's lawyer sent these over and I already know they're a problem. I think having your own lawyer is important. You should have a lawyer that you are comfortable working with, I mean, I have clients who will say to me, "I don't really want to pay you to draft the letter of intent, but will you look at the one that I draft before we send it out? And, does that save them some money? It might, but it makes them happy. So that's good. What else would I say is,
Well, what would be some of the key things that someone should be asking when they call around looking for an attorney? Because I mean, people will
yeah,
often have an attorney in their life for family or real estate needs, but obviously this is different, right? So,
it is
so when
different.
somebody
Yes.
is calling around and looking, online or looking at ads and things, what should they be looking for in those initial conversations with potential candidates?
Yeah, well, I mean, if you were in an automobile accident and you wanted to have a lawyer represent you, you would definitely have not only an idea of what type of lawyer, what type of practice they should have, but you should also then, once you narrow it down to a few attorneys, you should interview those attorneys to make sure they're a good fit for you, that they're going to take care of you. It's the same thing with an M&A attorney. You're going to want to look at, for attorneys who have that M&A experience. I mean, I can tell you exactly how many deals I closed last year, the industries that they were in, the purchase price. I can give you all that type of information, so you can see that that I have the experience, and then you'll want to work, talk with me to make sure that you get along with me, that you think I'm going to be looking out for you, that you think you can make suggestions to me that I'll listen to, that I'm going to take care of you. But yeah, I mean, I think that you definitely want somebody who has experience doing transactions. One way you can, an easy way to do that is to look at somebody's website and look at their, if you pull up their website and almost everything on there is about divorce and child custody, they're probably not the right fit. They probably don't have the experience that you need. So I think doing a little due diligence like that, but also almost all my business comes from referrals, and
Hmm.
I have CPAs around the city who know me, that I work with, and they work with me. We have mutual clients together. So it's always good, I think, to ask people that you trust from in your business community. Could be your banker. You might ask your loan officer, who do you guys typically work with on these types of transactions, or who do you see coming across your desk more often than not? And I think that kind of information will help you, find out, and it can make a difference. And one of the ways I've seen it make a difference is that if you have, for example, a trial attorney, somebody who does primarily litigation work, their
Mm.
approach to solving issues and problems is different from my approach. Typically, they're much more adversarial. Everything's a fight. There aren't as many, perhaps, filters or tiers. Everything is, DEFCON 1, and everything's a huge fight, and that could impact your transaction. It could slow it down quite a bit. It could focus you on things that really aren't as relevant for the closing.
Yeah. Well, Joel, I think those are great bits of advice for someone who needs to go out and find someone to help with the paperwork on a deal. For anyone that wants to reach out and find you on the internet, where should they be looking?
It's My name is right there at the bottom. If you just type in my name.com, no spaces, right? JoelAnkney.com, it'll take you to my law firm's website.
And as soon
And,
as we're
and I'm on
finished, when
LinkedIn.
and
Sorry.
and as soon as we're finished here, it takes a little while for me to be able to edit the show notes, but I'll add your website and your LinkedIn link to the show notes here. So anyone who's
Great.
listening to the recording or whatnot, just go into the show notes and you'll be able to find Joel. And just a reminder for everyone, Joel's book is called "Here's the Deal," and there is an Amazon link to my Amazon bookstore, and I put this book into my bookstore. So if anyone is interested in finding the book or any of the other books that I've recommended over time that I've enjoyed reading, you'll find them in my bookstore too. And I'll put that link is down in the show notes as well. Um, and this has been great, Joel. Thank you very much for coming today.
Thanks, David. Thanks. I've enjoyed both of our conversations. I hope I've given you something that'll help everybody.
Awesome. We're going to say goodbye, and we're going to play a message from today's video sponsor. and then I'll see you in a few minutes. Special thanks go to today's video sponsor, Mark Willis of Lake Growth Financial. Mark helps people better manage their personal wealth and business finances through the Bank on Yourself insurance strategy. This is something I've done personally and I've gotten lots of positive feedback from people I've worked with over the years. Go to newbankingsolution.com to find a playlist of all the interviews I've done with Mark and to learn more about the advantages of these programs. While there, sign up to arrange a conversation about what this solution might look like for you. So, how can you learn more about buying, selling, financing, and managing small and medium-sized businesses? Easy. Head over to my blog site at davidcbarnett.com. You'll find hundreds of articles and videos, all for free. You'll find links to my books and online courses, and you can sign up for my email list and get emails covering topics that interest you and be notified of new videos. This episode of Small Business and Deal Making is brought to you by SMBpodcastnetwork.com. The network is a collection of podcasts and shows from around the internet which focus on bringing you interviews with amazing guests who share actionable advice, ideas, and information for small and medium-sized business owners and entrepreneurs. Visit www.smbpodcastnetwork.com to find more great shows and easily subscribe to be notified of new episodes. It's a great way to discover quality content. And if you've discovered us today via the network, then I hope you're enjoying the show and will consider subscribing directly so you never miss any one of our great episodes.